Hi, everyone. Thanks for joining us. My name is Stephanie Haynes, and I wanted to thank everybody for attending this special virtual workshop on estate planning with our local attorney, Ben Jerner from the Jerner Law Group. So I am the director of Philadelphia Family Pride. We are a group of LGBTQ-led families in the Philadelphia region. I just want a couple quick notes. One is to note that this session is being recorded and live streamed to Facebook. So Ben will give his presentation, and then there will be time for questions, both from in the Zoom meeting and from the Facebook chat. So if you're in the Zoom meeting, please keep your audio muted, and we can turn that on for the question period. And those live on Facebook, you can ask questions anytime during the chat. So I'll be keeping an eye on those, and then we'll ask Ben later. But by way of introduction, I just want to say Ben is the managing partner and founder of the Jerner Law Group. He's practiced law in Philadelphia for over 20 years, concentrating his practice on estate planning, probate, estate administration, adoption, and legal issues affecting the LGBT clients for his practice. So I'm going to turn off my video and I'll let Ben give his presentation. Reminder again, for those on Zoom, to keep off your audio until the question period. All right, thanks so much, and take it away, Ben.
Thanks, Stephanie. So today I want to talk to you about some estate planning issues and concepts. This is really basic estate planning. As Stephanie mentioned, let's get past these. My firm has sort of focused on issues affecting the LGBT community, and for a long time, these documents were particularly important when folks couldn't get married. And now I think that there's in some ways sort of a false sense of security that marriage will sort of take care of all these things for us, and that's just not the case. So I'm going to go through, explain some of the basic documents that I recommend for everybody. And then, as Stephanie said, we'll take questions at the end. So here's the basic estate planning documents. This is the list of them that I recommend for everybody. Wills, general durable powers of attorney those are powers of attorney for financial matters, healthcare powers of attorney, living wills, and then for Pennsylvania residents, something called a standby guardianship designation. Other states may have this. New Jersey does not currently, but we'll sort of talk about what those documents do. Okay, simple wills. These are sometimes referred to as outright distribution wills. And basically, these are just like the most basic wills that you can have and sort of the basic things that they can do. And I'll talk to you a little bit later about sort of who might be an appropriate candidate for this and who might not. But just so that we're all sort of on the same page in terms of what these terms mean. A will is a document that sets forth your wishes regarding, number one, beneficiaries, which is who's going to receive your property after your death. You know, that might be your spouse, that might be kids, that might be a sibling, whoever, a charity, whoever it might be, that's a beneficiary. Your executor is the person or people that you would like to sort of take care of administering your estate. And that basically means making sure they figure out what all your bills are, if any taxes are owed, gathering up all of your assets, you know, paying the taxes and debts that are owed, and then whatever's left, making sure it gets to your beneficiaries who you've intended to receive certain things. A custodian is a person who can hold property for a child, whether it's your child or for another child, until the child is a certain age. And a custodian is a statutory creature, so it depends on the state law where you are in terms of what the age limit is and things like that. In Pennsylvania, when you're doing a will, you can actually leave property to a child and leave it to, what you do is leave it to the custodian to take care of that property, and you can extend the time when the custodian holds it until the child's 25. Now, in New Jersey, you can only extend it until the child is 21. But that's what that person does. And that person can use the money and or property to take care of the child for certain things, limited things, you know, during the course of the time that the custodian has the property. And when the child turns whatever age you've specified, let's say in Pennsylvania, you've chosen 25. When the child turns 25, Whatever property is left must be turned over to the child. Guardian. Now this is particularly, this is frankly why a lot of people actually end up doing wills, is they have kids. And they realize that if if they have a partner or spouse, if those two folks are gone, who's going to take care of their kid? So that's where a guardian comes in. A guardian can be named to take care of minor children. You can also name an alternate guardian in case that first person either isn't around to take care of the child or can't take care of the child for whatever reason. There are certain things that a will cannot do. And this is, there's sort of some misconceptions that I hear from folks, and I just want to make sure that we all understand what a will can't do. Number one, if you own property jointly with somebody, there are certain types of joint property that you can leave, you can pass through a will, but certain types you can't. So if you own property with somebody as a joint tenant with right of survivorship, you cannot pass your portion of that property through your will, because as the name of that form of ownership implies, the survivor is going to own your share when you pass away. Another type of property ownership where that you can't pass through a will is property you own as tenants by the entirety. And that's when you have designated, for instance, on a deed, that you own that house or that real estate as tenants by the entirety, meaning that you own it with your married spouse. So even if I were to say in my will, I leave my portion of my home to Joe Schmo, it's not going to pass to Joe Schmo if the way I've titled the property is as tenants by the entirety with my spouse. Other types of property that a will not control is life insurance benefits where there's a beneficiary designation. So in other words, if I've said in a beneficiary designation, the beneficiary is my spouse, an alternate being kids, it doesn't matter what I put in my will, that life insurance benefit is going to go to my spouse, and then if my spouse isn't around, then to my kids. Same thing with retirement accounts. So the only way that you can leave, that a will would control life insurance benefits or to retirement account benefit would go, is if you, in a beneficiary designation, for instance, left that to your estate. Most folks choose not to do that for reasons that are sort of beyond the scope of what we can talk about today. But just know that, you shouldn't be trying to name a beneficiary of life insurance benefits or retirement accounts and things like that in your will. All right, so then what a simple will can't do or shouldn't do? There are many, many reasons why you might need a more complex will. Most often what I see from folks that would make a simple will be inappropriate is if they wanted to, for instance, leave assets to a child or to children, but they didn't like the idea of having to turn all the assets over to a child, let's say at 21 or 25. If you wanted to provide some further control over how and when children or anybody else is to receive property through your will, you would probably want to do what's called a testamentary trust. And that's a trust that can be contained in your will that will, set forth the rules of the road as to when and how different property should be distributed to different people or charities or whatever it might be. Similarly, if you have a beneficiary that you want to leave property to who is disabled and who is either receiving or applying for certain types of government benefits, you have to be super careful because you may leave a gift to somebody who's receiving a benefit. And if you left that gift to them and they could become ineligible to receive the government benefit. And probably whatever you're leaving them would not be enough to offset that lost benefit that they could lose just by virtue of being named as a beneficiary. So these are just some things to sort of keep in mind. Some other scenarios where a simple will may not be appropriate if you are a business owner and you want to provide some more instructions on how, let's say, a business might be wrapped up and things like that. So those are just some of the things to keep in mind. And I'm a lawyer, so I'm biased, but it's always really good if you can check with a lawyer who does this stuff. And you can say to them, look, my intention is to do the most basic, simple stuff. but let's talk about my situation and you can tell me whether that's appropriate for me. The next document I want to talk about is a general durable power of attorney. And this document identifies an agent who can handle your finances in case you're sick or injured and you can't manage those yourself. Lots of folks come in and say, well, I don't need that document because I'm married. And guess what? Your spouse does not have the right by virtue of you guys' marriage to be able to deal with your finances. There are some limited, for instance, if you have some joint assets, that spouse might be able to go in and use those assets, but anything that's in your name, your spouse is not going to be able to control. If you ever had a situation where, maybe your spouse tried to contact a credit card company or a bank or something and try to even just get information about the account, they're going to try to make sure that they're actually talking to the account holder and not to anybody else, including a spouse. So a general durable power of attorney can give that person, whether it's your spouse or somebody else, the ability, if you become disabled or injured, sick, whatever it might be, the ability to get access to information, access documents, make financial decisions for you. And it's particularly important too that you name an alternate, because sometimes, if somebody names a spouse or a significant other, maybe they're in a car accident together, and that spouse who you're now depending on to make those decisions for you isn't able to do it either. So that's why married, not married, doesn't make any difference. Everybody should have that in place. And if you can, at all possible, make sure that you have alternates in place. Healthcare power of attorney are sort of similar to the general durable power of attorney in that they specify who can make healthcare decisions for you if you can't make them for yourself. Now, in terms of healthcare decision making, if you can make a decision yourself, you're going to be making that decision. Doctors are not, and hospitals are not looking to try to get other people involved in your decision making. So if you can make them, they're going to look to you to make those decisions. This is for a scenario where, let's say you're in an accident of some sort and you have a head injury. You're not going to die. You're going to be just fine. But there might be medical decisions that need to be made to help treat you after an accident. And if you're not, because of your injury or maybe some medication that they've given to you, if you are just not able to make or communicate those decisions, you need to have somebody else who can make or communicate those decisions yourself, for you, rather. Now, a spouse in this instance can make those decisions for you. So if you're married, not an unmarried partner, but if you're married, a hospital or doctor would look to your spouse to make those decisions for you. However, again, stuff happens. And sometimes, you could be in an accident with your spouse, and maybe your spouse can't make those decisions for themselves or for you. So again, having that alternate in place, and these are often tough decisions for people. Sometimes the agent for a financial document or a healthcare agent for a healthcare document are sort of obvious and easy for people in terms of figuring out who they want to name, but that alternate can be tough. And I always encourage people to have alternates. And sometimes you have to do the best you can in terms of making decisions, and just know, what, I'm going to put this person down. Maybe they're not perfect, but it's somebody that I trust as much as I can. And you can always change that later. So it's not, set in stone. Next document is called a living will. And a living will is in some ways similar to the healthcare power of attorney in that it's somebody who's going to be making decisions for you if you can't make them for yourself. But a living will goes into effect only when you're either in a coma that you are not expected to wake from, or you're at the end of a terminal illness and there's nothing else that they can do to treat you, to make you better. And you either can't make decisions for yourself or you can't communicate those decisions. So a healthcare power of attorney is not necessarily end of life stuff. Again, that could just be, healthcare power of attorney might be, you're going in for some sort of an outpatient procedure and you have to be under anesthesia. Well, you can't make or communicate decisions when you're under anesthesia. But that's not when a living will comes into play. Living will only comes into play when you're, again, either in a coma that you're not expected to wake from, or you're at the end of a terminal illness. And so this document provides for who will make decisions for you. It will also, very importantly, decide what you want to have happen. So if you are, let's say, at the end of a terminal illness, and there's nothing else they can do to treat you, and you can't make or communicate your own decisions, there might have to be a decision made as to whether or not you go on a ventilator or on some sort of other machine just to keep your body going. And you can say in your living will what you want to have happen. You might say, look, if I'm at the end, I don't want to have my life extended unnecessarily. You might say, and some of my clients do, look, give me the works. I want everything. I want to be kept alive no matter what. There's no bad decision here. The bad decision is not making a decision or not explaining to folks, preferably in writing with one of these documents, what it is you want to have happen. Because it's that uncertainty when people don't know really what you want, or maybe you have different people in your life who, one person might say, oh, I know what he wanted. We talked about it 20 years ago, and maybe somebody else says, well, I talked to him about it 10 years ago and he had a different opinion. And when you get into those kinds of, you might have two very well-meaning people trying to do the best by you, but they may have different ideas about what it is you wanted. So putting it in writing is really, really critical and really can save a lot of pain and agony for your family and friends who are sort of trying to figure this stuff out. And also just say, in terms of the healthcare powers of attorney and living wills, a lot of attorneys do these as separate documents. I actually do them as a combined document because these documents, after you do them, they should go to certain folks, including your primary care doctor. And to me, it's just easier to give them one document as opposed to two. It's not wrong to do it as two. It's not wrong to do it as one. Just different attorneys do it differently. Okay, for Pennsylvania residents and other states that may have these types of documents, I'm going to talk about Pennsylvania because that's the state I know. A standby guardianship designation will allow you, if you're a parent of a minor child, to name a co-guardian to assist in the care of the child with you, or if you pass away and the other parent, if there's another parent passes away, somebody who can step in as a guardian of the child immediately. So I'm going to go back and explain a little bit why that might be necessary. As you might remember when we talked about the will, you can name a guardian in your will. The problem there is, and that's a very good thing to do, don't get me wrong, that's great. The problem sort of practically is, after you pass away, if you're sort of the last parent of this child, and then you pass away, you've named somebody as a guardian, but that guardianship doesn't really become official until a judge says it is. So if you've been named as a guardian in somebody's will, and you're going to accept that job, you would petition the court where the person passed away, and presumably where the child is living, and ask the court to sort of formally appoint you as the guardian of the child. It takes time. And practically speaking, that child is probably going to be living with you already. But what if there's a medical decision that needs to be made for that child? Or what if there's some decision about school enrollment or something along those lines? There may come a time when there's a question of, do you even have the legal authority to make this decision before the judge rules on whether or not you can be a guardian? That's where standby guardianship designations sort of come in and are very helpful. Because what they can do is, if the last parent of a child who's living then passes away, it will create immediately a legal guardianship. It's temporary, it's only for a couple of months, but it's to provide you with enough time to then make that application to the court and get that formal guardianship approved. So again, it doesn't provide permanent guardianship just by virtue of being named as a guardian in this document, but it gives you that legal authority to act while you're also proceeding with the court process to get that guardianship formally and permanently put in place. The other great thing this document can do is, let's say, if there's only one parent, let's say that parent is sick and just can't care for the child, or there's two parents and both parents are sick and can't take care of a child. There can be you can name a co-guardian to assist you during that time. So in other words, you don't have to lose your parental rights just because you're gravely ill. You can just have, by virtue of this document, and you name somebody as this standby guardian. If you become too ill to care for the child, that person can step in and help. When you get well, that the legal rights that person has will drop away. And again, it can come back if it's needed. So it's very flexible. And you can name, you can specify in the document sort of under what circumstances you would want that standby guardianship to sort of come into being, come into effect. Now in that document, under Pennsylvania law, the person who is signing the document, we'll call them the declarant, will specify who's going to be that standby guardian. If there's another parent, whether it's a spouse or whether it's an ex, the other parent needs to consent to that standby guardianship designation. So it's not as if you let's say you have an ex with whom you have a child, you can't just on your own name a standby guardian to step in. You have to get the consent of the other parent. Okay, and in that document too, you can name alternates, because again, alternates are always a good thing to have and important to have. I wanted to talk a little bit, especially now, about some challenges to getting these documents done. Because I mean, I can sit here and tell you what the documents are I think everybody needs, and then you're like, you know what, I can't even leave my house. How am I going to get these documents done? And some of these challenges are, always around. Cost, for instance. But for right now, so costing it, that's always an issue. A lot of people, because of the cost of having an attorney, will just turn to an online, download a document kind of deal. That's not horrible. I mean, it's better, I suppose, to have that than not to have anything at all. But if at all possible, again, just because when you really start talking about what your situation is, who the people are that are important to you, who's in your family, your goals and your values, you might find that you're not really an appropriate candidate again for like a simple will, or something along those lines. So there are, to me, spending a little bit of money, if you have to, it's well worth it. I mean, think about what you spent on if you ever bought like a refrigerator, right? You're like, oh, I better buy a nice refrigerator to keep my food safe. How much did you spend on a refrigerator, right? Well, think about it now. What you're talking about is keeping all your assets safe, or at least trying to make sure that they go to where you want them to go, and people are in charge of them who you want to be in charge of them. So again, to me, it's well worth spending a little bit of money if you have to make sure it's done right and the way you want it to be done. Right now, we're doing, I'll throw a little pitch in here. We're doing a sliding scale for estate planning right now, for simple estate planning. And so it's not going to cost you anything. So now's a great time to do it, and there's probably other attorneys doing this too. Either a low cost or free service just to get these documents for people. Because again, my feeling is that I want to make sure anybody who wants these documents, especially right now, can get these documents. Another challenge is just access to attorneys, so how you figure out what the right attorney is to go to. That's a bit of a challenge. It can be. Some things you can do is contact your local lawyer referral service, and if you tell them you just need basic estate planning done, there's probably lots and lots of folks on that list that you can get referred to. Obviously, you can use the Google and do it that way. If you are concerned about if you're an LGBT in the LGBT community and you want to make sure you can get to an attorney who is sensitive to those issues, or if you're in some sort of non-traditional, a poly relationship or something like that, there's ways to find attorneys who are, who will work with you with those types of families too, those types of relationships too. There are LGBT referral sources. So You just got to look a little bit, that you can find them. You can find them. And if anybody needs help finding them, feel free to, I'll give you my email address at the end, and feel free to email me, and I can send those referral sources to you. Another huge problem right now is how the heck do you sign these documents? I mean, let's say that you find an attorney, you feel comfortable with that attorney, you can afford whatever they're charging, and you get the documents done. How are you supposed to sign them? I mean, most of the time, before the COVID-19 hit, we would have folks come in my office, and we would have every single document signed by the person, by 2 witnesses who are not related to the person or not named in the documents, and by a notary. That's just not possible to do right now. Some attorneys, to get around this, are doing drive-by signings where, basically the client will drive up in a car, and then I guess it would be, the notary is standing on one side of the car, and maybe another witness is standing on, sort of people sort of surrounding the car, and trying to keep sort of a social distance that way, so that we can still be present to witness and notarize documents. So some attorneys are doing that. Some states, including Pennsylvania and New Jersey, have put in place emergency provisions regarding notaries. So right now, for instance, in Pennsylvania, as these estate planning documents that we've just discussed can be notarized using an electronic notary, e-notary. The problem I'm finding with my practice is no one has qualified yet, or very few people have qualified to be e-notaries. They exist, they're around, but I've only been able to find a couple in Pennsylvania. So for instance, in Pennsylvania, in order to use this an e-notary under this new law, has to be somebody who is a Pennsylvania e-notary. And I believe it's similar. New Jersey also put something in place recently around e-notaries, but again, it has to be a New Jersey e-notary. You can't use somebody from another state. Excuse me. So you have to be sort of careful. Again, those folks do exist. They're hard to find, but they do exist. Some documents require two witnesses, though. So, there's no law that I'm aware of, at least not in Pennsylvania or New Jersey, that provide that the witnesses can do this electronically. So that's another challenge. I'm sort of thinking this through. My mom wanted to get a document signed, and we were sort of talking through, okay, if I stand on sort of one side of the driveway and, the neighbors stand on their side, can we somehow do this where they're watching me sign, but not next to me, not near me? So you may have to get a little creative to get to make sure you can get the document signed properly. I suppose you could do, again, sort of a drive-by thing with witnesses, and maybe do that. You're doing the drive-by, the witnesses stand outside the car, you're in the car if you have a car, and you do an e-notary at the same time. But these are some of the challenges we're finding right now. And honestly, I don't have a perfect solution for folks. I wrote up for my clients in Pennsylvania, for instance, it's a 3-page single-spaced instructions for signing documents, and said, here's the different options that you can look into and you can do. It's very complicated. But this is, we're sort of trying to do the best we can given the situation that we have. So I think that was all I had in terms of what I wanted to sort of present and sort of put some of these ideas out there. So I just want to take some questions if we have any questions from folks.
All right, so I'm going to moderate this part. Thank you so much, Ben. That was really great. I just have a couple questions that occurred to me so I'll just take the moderator prerogative and ask my questions first while other folks are getting a chance to type theirs in. And again, folks on Facebook, you can type yours into the chat. I'm keeping an eye on that. And then anyone on the Zoom meeting can also type into the chat. So you mentioned at the beginning that being married doesn't, automatically mean that various things are taken care of. And as you went through the different documents, you talked about, what's not covered by marriage. Is there anything different or extra that people should do if they're not married to their partner? So that's my first question, then I'll ask a follow-up.
Yeah, I mean, if you are not married, you have to have these documents in place if you intend for that person to, for instance, receive property. If you're not married, well, there's a caveat I'll talk about in a second. If you're not married, you really need to have a will in place to make sure that your partner will receive property or have those beneficiary designations that we talked about a little bit, for life insurance benefits, retirement benefits, and those kinds of things. Make sure that that person is named as the beneficiary there. Otherwise, they may not receive anything at all. The one caveat I would say, especially for Pennsylvania, and again, this is very state law specific, but in Pennsylvania, for folks who entered into what's called a common law marriage before 2003, there may be some ways that we can have, let's say, a surviving partner declared to be a common law spouse even after their partner has passed away. Those are a little bit tricky. Again, very state law specific. Some states don't even permit common law spouses, and Pennsylvania doesn't either anymore, but they do recognize those marriages, those common law marriages that were entered into a long time ago. So, for instance, I just had someone contact me this week who they've been together for 30 years. They were not married. His spouse passed away and did not, they weren't able to find a will. They thought that the partner had done a will and couldn't find it. So now the surviving partner of 30 years, thinking that they were all set in terms of having their deceased partner having a will in place, has nothing. Wow. So we have to talk about, for instance, do we want to move forward and have, through a court action, have you found to be a common law spouse, which would then give you all the same legal rights and that a spouse that where you'd enter into a ceremonial marriage, you'd have all the same rights as a sort of regular marriage. But again, that's tricky and it's very state specific.
Okay, great. Thank you. My other question is, if people who have children have not done a second parent adoption, I presume your answer is going to be they should do a second parent adoption, but also how does that impact the estate planning documents? And maybe you can just talk a little bit about the cost and the importance of the second parent adoption. And
yeah,
it's kind of, I know it also is like the birth, having your name on the birth certificate or not too. So maybe if you could talk a minute about that.
Yeah. Okay. So let's start out with a married couple who have a child. If you're a married couple and you have a child, but one of the spouses is not genetically related to the child and hasn't adopted the child, the position we take at my firm and have taken for years and years and years is that non-biologically related or non-adoptive spouse is still a parent to that child if they act as a parent to the child. Again, this is very much about state law. So some states will recognize parental rights based on having acted as a parent, and some won't. In Pennsylvania, they will, and we always make that argument that person is still a parent, even if those formal legal relationships are not haven't been created. However, it can get tricky. If you're not either biologically related to a child or you haven't adopted, it opens up a whole can of worms for somebody to argue that you weren't really a parent. So for those types of situations, even when, let's say the non-bio or non-biological related spouse or non-adoptive spouse is on a birth certificate, that doesn't break your parental rights either. Just being on a birth certificate does not necessarily equal parentage. So for those folks, if you're not biologically related or you've not adopted that child, we always recommend that we do a step parent adoption in that case. And same for unmarried couples who might have a child together. That's called a second parent adoption. Those are always recommended. So don't assume. First of all, don't assume that your relationship with the biological parent or the other parent will necessarily last forever, and that your relationship with that child is safe. As we know, lots and lots of folks break out, and we see them every day. Unfortunately, come in the office with horrible stories of I had this child with somebody, and now she's moving to some other state and is denying me access to the child. Happens all the time, unfortunately. So the only way to really secure your rights are through doing an adoption. And also, again, these things are very state specific. So even if we could make an argument, and maybe we'd win in Pennsylvania, that if you acted as a parent, you are a parent. Well, some states, your ex may move to a state where that relationship it is not recognized. However, in every state, an adoption is recognized. That's why an adoption is so critical.
Okay, great. Thank you. That's all the questions I had. And if I'm just going to give one more minute for other folks to chime in. I don't know, the other person on the Zoom call wants to ask a question. You could either type it in the chat or just unmute yourself and ask. So I'll give you a second to do that. Is there anything else, Ben, while we're waiting for that you have thought of that you want to add, or other kind of wrap up comments that you might have?
Actually, I realized I didn't respond to your question about cost for the adoption. I don't know what other people charge. For us, it's going to be somewhere, I think you're going to end up spending somewhere around $2,000 for most jurisdictions. It depends for us a little bit on the county where you are and the state where you are. In New Jersey, it's just become much more easy and much less expensive to do these. Because they're no longer requiring hearings for certain adoptions. So we can charge less because we don't have to go to court. We can file the paperwork and take care of all that stuff, but we don't actually have to go to a court hearing, which means that we can charge much less for those services. But you're probably looking at spending a couple $1,000s. But I'll tell you, when you get involved in a custody dispute, those can range anywhere from probably a minimum of $10,000 to $100,000 or more. So, spending a couple $1,000s on the front side in order to avoid that kind of incredibly costly litigation is well worth it. It's money well spent.
Okay, thank you. And then just for folks who, like us, who live near to New Jersey but live in Pennsylvania, where the second parent adoption or step parent adoption takes place, is that where the child was born, or how does that decided?
From what I understand, it's if you live in New Jersey, that's definitely where you do the adoption. And I believe that there is, and I don't have it in the top of my mind of how many months it is, but I believe you have a certain number of months after the birth of the child, if the child's born in New Jersey, to go ahead and file for the second parent or step parent adoption there. But if it's been years, like my kids were born in New Jersey, 8 and 11 years ago, it'll be too late for me at this time to file in New Jersey for a second parent or step parent adoption. I would need to do that in Montgomery County, which is where I live. So there again, there's a window of a couple of months after the child's birth, and after that time, you really need to do this in the state and the county where you live.
Okay. Well, thank you so much, Ben. Did you want to put up your email address or provide that for folks?
Unfortunately, I don't have a slide that says it, but I will just say what it is. So it's B Jerner, that's BJERNER at jernerlaw.com. So BJERNER at JERNERlaw.com.
Great.
I'm happy to answer any questions people have, follow-up questions, or like I said, if anybody needs sort of direction on maybe some friendly attorneys to go to, I'm happy to try to help with that as well.
Okay. Great. Thank you so much, Ben. And thank you everyone for attending. And we will also post the link on our webpage so that folks can find this and watch it later. But again, thank you so much.
Thanks, Stephanie.